Before we begin today's webinar, I would like to acknowledge the traditional owners of the lands from which we are broadcasting today. I'm broadcasting from the land of the Widjabul people of the Bundjalung Nation. We pay our respect to elders of the land, both past and present, and we extend that respect to any Aboriginal or Torres Strait Islander people attending the webinar today or watching the recording. Welcome to this Legal Aid New South Wales webinar on how community workers can help support clients exposed to the care and protection system. This is part of our Law for Community Workers series. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. The session is scheduled to be an hour. We may go slightly over time to ensure that we have some time to answer questions, any questions that are asked. After the webinar, you will receive an evaluation survey and we really do value your feedback. You'll also receive an email with information about some resources that may be referred to in the webinar today. I'll now hand over and introduce you to your presenter, Daniel Kennard from Legal Aid's Family Litigation Team. Thank you, Daniel, and welcome.
Thank you so much. And I too would like to acknowledge that I'm broadcasting to you from the Gadigal lands, and I pay my respects to elders past, present, and any Aboriginal people who may be, or Torres Strait Islander people who may be joining us in the webinar. I'm very honoured and humbled, I guess, to be asked to do this seminar. And I think that community workers have such a vital role to play in the care and protection system that it's a real great pleasure for me to be able to talk to community workers and share some of my knowledge about the law, but really about interacting with our shared clients so that we can get outcomes that are going to work for our clients and hopefully achieve the goals that we will set for ourselves in relation to protecting children and providing parents with dignity and respect. When we think about care and protection, one of the questions I think that we should be asking ourselves is, what is it really about? And I guess the answer to that question is going to depend upon from whose perspective you are looking at the system. From the perspective of our parent clients, child protection is effectively about the government or the state telling them that they are bad parents. It's about the state telling them that what they're doing or not doing, and there should be a word there, is not good enough to ensure that their children are safe. For our parent clients, the child protection system is really all about them. And that's a really interesting perspective for us to consider, because often for our parent clients, having children and being a parent is the most important thing in their life. And they're being told by a system in which they live, in which they participate, that they are not good enough. It's a system that may reinforce their experience of the world as an unfair, an unjust, a complex, and an unsafe place for them. So from a parent's perspective, care and protection is not necessarily a positive thing. In fact, it's a very, very frightening thing that's well beyond their control. For us as service providers, next slide, please, we say care and protection is about the children. It's about providing a system that ensures that children are safe, are protected, and have their potential met. For us as workers within the system of care and protection, we have a moral imperative to protect children, and using that moral imperative, sometimes we're able to cross the line in what would otherwise be difficult decisions or difficult behaviour. So for example, when we need to share information about our clients' conduct, if it's consistent with the best interests of the children, we say the children's needs will take priority over the needs of the parent. Now, that is a rational and appropriate position for us to be in, but as a parent client, they may not share that view. They may find that, they may consider that some form of a betrayal. And it's important, I believe, and this is my personal belief, not necessarily that of Legal Aid, that it's important, I believe, for us to try and understand where our clients are coming from so that we can value add to the services we provide them. Next slide, please. So child protection is not something that's new, and it's not something that's just New South Wales based. It's grounded in an international framework which is exemplified in the Convention on the Rights of the Child. And interestingly enough, actually, child protection systems predate the Convention on the Rights of the Child by a long, long way. And there has always been a system to protect vulnerable people inherent in the Supreme Court jurisdiction in Westminster English-based legal systems. I won't go into the details in relation to that, but I do note that it's important for people to understand that under the Convention on the Rights of the Child, there's a few pretty interesting articles, and I won't go through all of them, but I'll just read to you Article 3, 9, and 19. So Article 3 says, all organisations concerned with children should work towards what is best for the child. I should put my glasses on when I'm reading. Article 9 says, children should not be separated from their parents unless it is for their own good. I mean, who's going to judge what's for their own good? For example, if a parent is mistreating or neglecting a child, children whose parents have separated have the right to stay in contact with both parents unless this might cause harm to the child. And Article 19 says governments should ensure that children are properly cared for and protect them from violence, abuse, and neglect by their parents or anyone else who looks after them. So there's an international obligation on Australia to ensure that children's needs are met and that they are protected. Next part of this slide, please. In New South Wales, there's a large legislative framework that deals with child protection issues, and the act that mostly deals with them, the piece of law that mostly deals with them, is the Children and Young Persons Care and Protection Act 1998. Parent clients might think about this as a parenting act, the act that regulates their parenting, but actually it's got a whole lot of other functions. Other issues that are relevant for parents in relation to child protection include the Crimes Act. So there's nothing about being a parent that protects you from committing crimes against your child or from defending, from harming your child or causing harm to your child in a way that may violate the criminal law. There's nothing special about a parent that would give you immunity for that. There's also other legislation that might be relevant for your clients, which include the Child Protection Working with Children Act, the Education Act, and the Status of Children Act. In this seminar, I'm really just going to focus on the Children and Young Persons Care and Protection Act, because that's the primary piece of legislation that deals with child protection matters. Okay, next slide, please. I'm hoping to discuss the care and protection system in New South Wales from a client's perspective, but really from three different angles. The first angle is early intervention. So it's before the Children's Court has been involved in the matter. The second perspective is when a matter is before the court and you're dealing with a client who has a matter before the Children's Court. And the third one is what happens after court, what sort of services, what are the legal issues for a client after court has been completed. Today's focus for me and my hope is to give you some information about the law. It won't be everything about the law. The breadth of child protection issues and child protection legislation is very wide, but I'm hoping to provide a fundamental understanding of the law. To allow you to think about, as a service provider, issues in relation to evidence, and not the rules of evidence, but just how evidence may or may not be used. To talk to you about when to access legal support for your clients, and to also talk about the practical support you can offer your clients and what the process might look like. For many clients, the process is incredibly confusing. And to be honest, for junior solicitors or for any solicitor in the process, unless you've gone through it with a client, it's also very confusing and difficult to understand. And we don't have much at stake. The client has a lot at stake. So it's really important, I think, that we always review it from the view of the client. And in this case, when I'm referring to clients, I'm talking about parent clients. Next slide, please. Care and protection is different to family law, and it's important that we have an understanding of the difference between the systems. They do overlap, but there are some major differences. Family law is usually about resolving disputes between parents or caregivers about their parenting. It's a voluntary process, which means that parents can decide to participate or not. It can be resolved by consent. It's true that the court needs to be satisfied that an order of the court is consistent with the best interests of the children in the family court, which is now known as the Federal Circuit and Family Court of Australia. If you're an applicant in a proceeding and there's only an applicant parent and a respondent parent, then you can just elect to stop the proceedings and court's over. Sometimes there are circumstances where that can't happen. The best interest of the children is the primary concern, but the decision that the court is making is, given that these two parents cannot agree on how to best parent their children, what decision is in their best interest? So it's resolving a dispute between private parties about the parenting of a child. The Family Law Act is a federal-based piece of legislation. It applies to every state in Australia except for Western Australia, which has their own Family Law Act. And that Family Law Act generally is mimicking the Family Law Act that applies for the remainder of Australia. If you have a client who's in Western Australia, you just need to be aware that there are some slightly different rules, and Western Australia has its own family law court that deals with family law matters. Care and protection, on the other hand, is quite a different system. It's not a dispute between a parent and another parent or a caregiver of a child. It's a dispute between the state government, the state Department of Communities and Justice, DOCS, Family and Community Services, whatever you want to call it, and a parent about the safe parenting of their children. It's not voluntary. You can't opt into the system, or more importantly, you can't opt out. Parents don't choose necessarily to be subject to statutory orders. They may seek assistance from the department on a voluntary basis, but once you're in the system and certain things happen, it's not a matter for the parents to say, I no longer want to be in the system, because the matter's not really about them. It's not a consent jurisdiction. So even if all the parties to a dispute, including the department and the child's lawyer and the parent's lawyers, all agree in a court about what should happen, the judge or the magistrate in the children's court has to turn an independent mind to what is proposed and determine whether that decision or that order is in the best interest of a child. There's no equal balance in terms of power and resources. It's a parent with all their resources, or limited or limitations, versus the state with extraordinary resources. And so it's a very unbalanced way to resolve disputes. The best interest of the child is the primary concern, and the interest, welfare and well-being of the child is the fundamental principle upon which all decisions should be made. In that statement, the best interest of the child is the primary concern. We haven't got the parent's voice. There is a connection between the best interest of the child and a parent, but from a parent's perspective, they're not the focus of this act. The legislation is New South Wales based, and what that means is every state and territory in Australia has their own statutory regime, law-based regime that deals with care and protection issues. So if you have clients who cross borders or have come from interstate, they may have a very different experience of the law. And the only information that I'm providing you is information that's relevant to New South Wales. Next slide, please. So the Care and Protection Act, which is the Children and Young Persons Care and Protection Act, contains a number of sections, but the most significant sections are the first bits in the beginning of the Act, which relate to the principles of the Act and the objects of the Act. So the principles which underpin the administration of the Act is that the safety, welfare, well-being of the child or the young person is the paramount consideration. So any other consideration needs to come second to the safety, welfare and well-being of the child. The other principles that flow from that include things like the child's views should be taken into consideration, where possible children should be placed with a family member, etc. In relation to what I'd like to talk to you about is a secondary principle that is very relevant to the work that you might be doing with your client, is that any action taken under the Act must be the least intrusive intervention consistent with the best interests of the child, and that will protect the child from harm and promote the development of the young person. So the least intrusive intervention is the option that everyone administering the Act should be considering. And that, when they say least intrusive, they're meaning least intrusive into the way a parent parents a child. So least intrusive intervention by the state on telling parents how to parent a child, so long as that intervention is based on ensuring the safety, welfare and well-being of a child. And if there's a conflict between the least intrusive intervention, which is obviously taking no action, that would be the least intrusive, and safety, then safety is going to take the priority. Thank you. The objects of the Act are not about removing children from the care of parents. And in fact, the Care and Protection Act is really about ensuring that the state government provides resources to parents and communities to ensure that children are safe. So a number of the objects relate to the safety, welfare and wellbeing of parents, of children in the care of their parents by providing support. Another object talks about when we have to make a decision that impacts on the long-term well-being of a child, that decision should be guided by the permanent placement principles, which say that children don't thrive in circumstances where there is uncertainty, and we need to make timely decisions about permanent accommodation for the children if they can't be placed with their parents. If they can be placed with their parents, we need to allocate resources to them, on the assumption, of course, that they've been removed. Children have a right to be in an environment free of violence and exploitation, and services need to foster spirituality, dignity and self-respect of children and parent participants. And the Act aims to support parents and carers, provide a safe and nurturing environment for children. Next slide, please. Other relevant provisions, and these are just really basic ones. And the reason why I'm going through these provisions fundamentally is to ensure that you're aware and when you're talking with parent clients about their experience with the law with respect to child protection, that this Act is not the Act, this Act is the Act that authorises the department to remove the children from the care of your parent client. But that's not really the aim of the Act. Really, the aim of the Act is to ensure safety and to set up a mechanism where the government can support families to keep together and meet the needs of children. So that the Act provides various legislative provisions that enable the Secretary, who's the person in charge of the Department of Communities and Justice, to provide services that promote raising children and young persons within their families. So they're things like community health centres have extra funding to provide, school lunches, or they look at ensuring that if people need subsidies or assistance to access psychological support or behavioural intervention for children, those services are available. There is a provision for disputes to be resolved early and through mediation and not court-based systems. And lots of your parent clients might go through different types of family alternative dispute resolution, things like family group conferences or mediations, or a range of other options, negotiations with the department. All of those options are saying court, removal, last resort. The department has some extraordinary powers to request assistance from particular government agencies. And if the department or the Department of Communities and Justice is of the view that a client's children are in need of care and protection, they can ask a government-funded service to provide to that client prioritised access to that service. Section 23 talks about definitions of risk of harm, and it's important that our parent clients understand that it's not just limited to what they may think of as traditional ideas of abuse and neglect, but it does include things such as a failure to obtain medical treatment when that's been recommended, a failure to attend school, being in a household where there is domestic violence, or it could include a prenatal report. And why I've highlighted that and why it's really important is that some of those issues might be contested. So on occasion, someone may define a risk of harm report as a parent who fails to obtain a vaccination for their child. The parent may have a reason grounded in fact, grounded in faith, grounded in ideas that have no merit as to why they've made that decision. It's important for us as service providers to understand that that might be an act or an issue that falls within the definition of a risk of harm, but our client needs to be probed and supported to understand that, and then understand what flows from that decision if that report's been made. So Section 27 provides for a regime of mandatory reporting and mandatory reporters, and I won't go into that, but most of you probably, if you're working with children or working in services that provide support for our parent clients, may be mandatory reporters. What's important is that your parent clients understand that and understand what that means in terms of their engagement with you. Next section, early intervention. All right. As sort of highlighted before, most early intervention and most work in the care and protection space is not about removing children. It's actually about preventing the need for reports to be made. And that sort of early intervention work, I think it's called primary care and protection work. I can't remember the regime, actually, I'm sorry about that. But it's education to parents. So some of those programs that you may see are just healthy eating programs or programs about safe co-sleeping or drug and, misuse of drugs and SIDS awareness, those sort of issues. It's about providing support to parents who need support, and it's about ensuring that services are available to support parents when they can't parent their children without that support. The aim is for those services to be made to vulnerable families. So next bit of this slide, I think. Once a report has been made, sorry, just back up to the early intervention, most of those services allow the client to have some autonomy and control about whether they access that service. Once a report has been made to the department and the department has assessed that that report requires some response, then our client's autonomy is in some way infringed by the process. The reason for infringing on their autonomy is because the Act aims to protect children, but our client's experience of that is relevant to the way that we deliver services. Some of the ways that their autonomy or their whatever they call rights will be infringed upon is that the department, when I'm talking about the department, I'm meaning the Department of Community and Justice, the Statutory Child Protection Agency, will gather information from a range of agencies that help them assess whether this child is in need of care and protection. Those agencies can include the court, hospitals, doctors, and schools. Our clients may not know that the department has gathered that information, and they will not know what information is held by those other agencies unless they've been before the court. So sometimes there'll be conflict between our client and the investigating agency, because the investigating agency is relying on information which our client doesn't know they have and doesn't know what that information says. And that's really problematic for clients because it really is very disempowering. So for example, there may be a hospital report that says that our client was a perpetrator of, well, maybe a police report that says our client was a perpetrator of sexual abuse on their 3-year-old child. They don't have a 3-year-old child, but the record says that because it's been either the wrong client or incorrectly recorded. So they may have been the subject of sexual abuse as a 3-year-old when they were a child. Our client won't know that information. They won't know the department has that information, but they will know the effects of that, the way the department assesses whether that information places their child at risk and whether that child needs to have an intervention of a more escalated intervention as a result of some of that information. Our clients will also be interviewed by the department, potentially, that might be their response, and service providers will be interviewed. And this, again, it's important what information is shared with the department. Of course, you have to share the information that you have, but it's important to consider how that may be interpreted by the department and how that may be interpreted by your client. The children of the client may be interviewed by the department with or without their consent. And that's very, very confronting for your parent clients, because they normally decide these things. And then based on that analysis of information, decisions are made about what further action to take. This is at the early intervention stage. Those decisions made will relate to whether the child is at risk. If so, what is the extent of that risk? And what needs to happen for that risk to be reduced to an acceptable level? The price for the department in making the wrong decision is pretty high. However, for our client, their reaction may be a trauma-based reaction. The experience that our client may have is that their parenting is being criticised, and that even if this is not the case, that their children are at risk of being removed. That may trigger a number of trauma-based responses, including the response of fawning, which is a new concept to me. It's probably not new to any of your practitioners, but this year it's sort of come more and more to my attention. The fawning response is really important for us to understand, because what it may mean for our client in their engagement with the department is that they may tend to agree and commit themselves to things that they don't understand and they can't do. And what that then means for them is if they fail to demonstrate insight and understanding or fail to follow through their commitment to the department may make adverse inferences about that. So we need to be aware that even at this very early intervention stage, there could be trauma-related responses from our client, because there's nothing for some clients more traumatic than either revisiting what happened to them in their childhood when DCJ or whatever they were called visited their family, or having their own children removed. So trauma reactions are not helpful for our client at this stage, but being aware of them in delivering services can be really helpful. Okay, next slide, please. Unless a child is at imminent risk of serious harm, removal is not really the first thing the department's considering, but a trauma response, as I just said, to the department's intervention can turn a low-level acceptable risk of harm into a risk of serious harm. So just even on the most basic, the flight issue, if the department can't assess the risk, they can only assume that the child is at risk, because they have to act consistent with the best interests of the child and ensure the child's safety, welfare and well-being is the paramount concern. So if we don't know, if we can't quantify the risk, then we have to assume the worst. As a service provider, we can really, at the early intervention space, help our clients to understand the role and the function of the department. So they're not there to remove your children. They're there to ensure your children are safe. Can we use the department to assist us to ensure that the needs of our children are met and to meet our other untapped needs that are placing the children at risk? Help clients understand risk and articulate insight into risk. This is really hard. And sometimes the approach that I think that I can take as a lawyer, and perhaps service providers to parent clients can take, is to ask clients to stand outside themselves and look at the situation or the fact scenario that the department is alleging. Not whether those facts are true, but whether in that fact scenario, what do they think the concerns for their children, for those children might be. And if you can get them to stand outside of themselves and look at the risk, sometimes that's a useful exercise so that they can see why the department has those concerns, and that can then build a bridge to them understanding those concerns and then being prepared to work on those concerns. It's easy for me to say this to you, and it's easy for me to say this to our clients, but it's very hard to do that when you're feeling personally attacked if you're a client, to stand outside yourself. The other issue is sometimes clients don't have the right words for articulating insight, and it's important that we help them talk about that and help them talk about their understanding of course, they don't want their children to be subject to an environment where there is chaos arising from domestic violence. Of course, that's the case. We love our children, we want to change and protect our children, and we need them to be safe and secure. How can we talk to the department about that in a way that is authentic, but also demonstrates an understanding on the impact of the children, understanding of the issue on the impact of the children, or to the children and their safety. We need to take particular care in our record keeping, because sometimes those records may be subpoenaed, and sometimes a careless notation in a client record can do untold harm. So client failed to engage. Is that what you meant? Or did you mean that today she was really cranky and she didn't really want to talk to me, but she engages every other time? Client failed to understand the child protection concerns. Is that what you meant? Or did you mean that we didn't explain the child protection concerns in a way that she could understand them, so we need to do a bit more work? Often you might be right, sometimes you might not be, but those records have a lasting and impact on our way a court case can run. So be careful with those sort of words that the clients are often judged against. Next slide, I think. Help balance power differences. So sometimes the information that the department has is wrong, and sometimes the assumptions that the department is making about your client is wrong. Sometimes you might know that, and you might be able to be a powerful advocate for your client in a gentle and persuasive way to challenge the department in a way to change the power difference between the department's resources and your clients. So think about that. Help the client to understand and engage with the department. So part of this idea is that if we try and humanize the worker for the department as a person who is actually wanting to get job satisfaction about ensuring that your children are safe and not about removing the children from you, what do you think they need to know to be satisfied that your children are safe? And how helpful do you think it is in relation to their working in your best interests, not just your children, but in your best interests, if they feel that you are attacking them at every level? Doesn't mean you have to suck up to the department, doesn't mean that you have to agree with everything they say, but an authentic engagement acknowledging their goals may assist them do the one thing that you want to have happen, which is for them to recommend that they no longer be in your life. And so it's worth helping your client to understand that, maybe practicing it, maybe challenging them about some of the ways that they are interacting with the department, which may seem legitimate and consistent with their trauma history and their way of socialization, but just are not going to be helpful, and gently challenging and probing them on those ideas. Next slide, I think. There's a range of options. You can just pull, sorry, you can just pull all these ones up. There's a range of options that the department may think about working with your, offering to your client. And these ones are in absolutely no particular order. I should have ranked them in terms of intrusiveness, but they're in no particular order. So, but you need to be aware of them, because almost for every one of these, I would be suggesting that you consider referring your client for some legal advice or talking them through it really comprehensively, carefully, and thoughtfully, so that they can make informed decisions. So a temporary care agreement is an agreement for a client to temporarily allow the department to have care responsibility for their child. They are for a period of 3 months, and they can be extended for one further occasion, so up to 6 months. At the end of the period of the temporary care agreement, the department has to assess whether a child is in need of care and protection, or whether the goals have been achieved by the temporary care agreement. So they're not they're not strictly a respite option for a client, and they are voluntary. So if your client says, I no longer agree to a temporary care agreement, the child needs to be returned to your parent client, or the department needs to make an application to the court about a different option. Often, if a parent tries to terminate a temporary care agreement early and the department assesses that the risk issues remain there, the department will just make that application. So their consent to a temporary care agreement, or consent to any agreement with the department, is often an informed consent, but it's not necessarily a voluntary consent, even though a temporary care agreement should be voluntary. The other curious issue with a temporary care agreement is that there are 2 parents for most children, but the temporary care agreement only needs the agreement from one parent. So that's interesting. And you may have the parent client for whom agreement was not sought. So that's an interesting dilemma. And that's also one where you would get some legal advice. Temporary care agreements often make provision for children to have contact with their parents. And they're really useful in circumstances where a parent client needs to do something for a short period of time that's predictable and has a really knowable outcome. So sometimes parents just have no resources in the community at all to support their childcare. So when they're having an operation, a planned operation, they might have to place their children in foster care under a temporary care agreement. Sometimes if a person's going to custody for a short period, that might be the option. Rehab, that might be the option. The difficulty with rehab is if you don't achieve the goals of rehab, then you're really at risk of that temporary care agreement escalating into being an application for a children's court order. A parental responsibility contract is a formal contract, except it's not a legal, it is a formal contract under the Act between a parent and the department, which sets out things that they want the parent to do. So it's a contract to say, I will do drug testing 4 times a week. I will engage with whatever that word means, with the caseworker. I will do therapy. I will ensure my child goes to school. Parental responsibility contracts have meaning and are used in later litigation as evidence of what the department wanted the parent to do, and their failure to do them may give rise to an application being made to the Children's Court. The law has changed, and it used to be that a breach of a parental responsibility contract would automatically give rise to an application being made and a finding being made. That's no longer the case. But what is important for a parental responsibility contract is for our client to truly understand what they're being asked to do. And for you as a support worker, if you have any contact with the client during the phase of the parental responsibility contract, to ensure that what they're being asked to do is realistic and achievable and within the control of the client and won't be breached by the actions of somebody else. So sometimes they say the parental responsibility contract will be that our client will ensure that the children are not exposed to domestic violence. There's an ADVO that's protecting our client from the other party. But if the other party breaches that ADVO and commits an act of violence, which probably breaching it is committing an act of violence, commits an act of violence, then is our client in breach of that parental responsibility contract because of the actions of the third party? So they're the things that caseworkers who are fabulous, potentially, don't think about. And that's why we would recommend that you really, if a parental responsibility contract is being discussed, then we would recommend a referral for early legal advice. A parental capacity order is an order of the court. They will have legal advice, and I'm not sure why I put that there. That's an application is made to the court for a parental capacity order. And when I talk to you about options once court has been commenced, you will see that they'll be eligible for legal advice. A Section 38 care plan is a care plan by consent asking the court to change the parenting arrangements for a child. It's done under Section 38, which is a different part of the Act than normal court proceedings, because that section allows the court to endorse a court order by consent if the court satisfies in the best interest of the child without having to make some findings about the parenting of that child. So in the past, the court was required to find that the child was in need of care and protection and that the child could not be restored to the care of the parent before it made longer term orders for a child, allocating parental responsibility to a person other than a parent. Section 38 care plans allow a different option, allow that option to be available, but not without the court making those findings. So they're really good in circumstances where a parent just does not have the resources to parent a child because that child may have overwhelming disabilities. And if you have a client like that, and the department's talking about taking that child into care, that's an option that the parent should get some advice about. Can this be dealt with by way of a Section 38 care plan? Safety planning and case plans are documents that are either written or acknowledged by parents and the caseworker in relation to ensuring that a child is safe. They often talk about things like ensuring that a perpetrator of domestic violence won't come to the home, agreeing to take the child to school. Sometimes it's agreeing not to physically discipline the child. It's often what happens following the department's first contact with a family. They'll enter into a safety plan. A family action plan for change is very similar to a parental responsibility contract, but doesn't have a contractual basis. And I don't have as much experience with those as with other aspects of the care and protection, because these are issues and case management tools that the department uses before lawyers become involved. But they will set out what they want to see the family do. It's very similar. Go to counselling, not use drugs, attend a domestic violence course, do urine analysis, those sorts of things. A family group conference is a form of alternative dispute resolution where the department will invite extended family and family members into a meeting with a mediator for the family to come up with a solution for the safety, welfare and wellbeing of the child. And that solution may be how they're going to support a parent to care for a child, or it may be how they're going to arrange for that child to be cared for by an alternative carer. Lawyers are typically not welcome at those conferences, but legal advice before, during and after is welcome, and clients need to know what the consequence of making an agreement at a family group conference will be for them. And then the other alternative is to try and get the matter out of the care and protection system, and for parent clients to take control of the dispute by making an application under the Family Law Act. And if you do that before the departments commence court proceedings, the matters before the family court, and they'll apply family law principles. If you do it after the matters before the care and protection system, there's a level of complexity that I'll talk to you about at the end of the talk. I'm going to race through the rest of this because I'm looking at the time. Next slide, please. Early intervention also means early access to legal advice, and there's a whole range of legal services available, mainly by Legal Aid. The acronym LAFPA is Legal Assistance for Families Partnership Agreement, and that's an agreement between Legal Aid New South Wales, the Aboriginal Legal Services and the Department of Communities and Justice to refer families very early for legal advice. Legal Aid has an early intervention unit, which can also provide early targeted legal advice, and lots of community legal centres do legal advice. They won't do representation at court, but they will do legal advice. And the sooner a client gets to see a lawyer, the better. Can I just go back to that previous slide? Sorry, just the, yeah, that one. So those early intervention options, often as lawyers, and I think as community workers, we really pride ourselves in saying, oh, we've got an early intervention option for our parent client, and we've resolved this issue through using non-court-based measures. And that's really good, and that makes us feel good, and we think we've achieved a good outcome for our parent client, and I think that we have. But I think it's important that we always remember that before we congratulate ourselves too much, our parent client may not have the same view as we do. They might say that the government is still telling me what to do. The government's still judging me as a bad parent, and therefore, because of the way I see myself, a bad person. And if I don't do what they tell me to do, my kids are going to be removed anyway. So there's no voluntariness, there's no consent here. I'm just doing what they tell me. So it's important that we understand that even at that early intervention stage, the parents aren't necessarily welcoming this intervention. All right, sorry, next couple of slides. So when the children are removed, they can be removed either by a warrant, where there's a risk of serious harm. They're removed without a warrant, which is an immediate risk of serious harm, or through an application to the Children's Court, and then there's a provision in the Act that allows the court to ask for the children to be removed. Normally, in my experience, they're removed without a warrant, which is a Section 43, and the court, the department will provide your client with a notice of assumption or a notice of risk. A notice of assumption, which will set out the reasons why they say the child is at risk of immediate risk of serious harm. Thank you. Next slide. If the child has been removed, the department needs to take the matter before the court within 3 working days. Often that's not the case, and what the law says is that you can't get a case out of court just because a technical issue has not been met, and this is where parents see it as the process is quite unfair. So you can't beat the department's application because they didn't file within 3 working days, and the reason why that is because this is about the care and protection of children, and so where the department hasn't done something that they should have done, we still focus on what's best for a child. There's a range of orders that can be made, including an emergency care and protection order. That's that Section 46(1). I don't see many of them. Mainly they make an application for a care order. And I'll go to the next slide. The care application can only be made by the department. So a private parent can't make an application for removal or a care order under Section 61. They need to set out what their grounds are. They need to provide a report, and the application needs to be made within 3 working days. Sorry, yep, that's fine. Please go to the next one. Sorry, that's a bit boring, that bit. The report, I'll leave it at the establishment here, but the report that they provide is served upon the client, and it will contain information the client may not agree with and may not know. As soon as a child's been removed, they should be referred for legal advice if possible. If they've been served the documents, they definitely should be referred for legal advice if possible. The second page of the report that they'll receive, which is a report initiating care and protection proceeding or care proceedings, will say the court location, the court date, and the court time. And I'll tell you, I will give you some information at the end of the talk about what happens in terms of representation, but they'll be entitled to legal representation on that first occasion. If you go to there's 2 words that we hear a lot. One is establishment at this part of the proceedings, and the next one is the next slide. interim orders. So I've got these slides around in the wrong way, and that's because I just didn't correct them. But normally what happens on the first occasion, if a child is at imminent risk of serious harm and the department's wanting to take that child into care, is the child's been removed and they're asking the court to make a short-term order, placing that child under the parental responsibility of the minister. It is very easy, if the matter is before the court, for the court to be satisfied that it's in the interest, safety and welfare of a child for that child to be removed from their parent, given these circumstances, on an interim basis. And so mostly what will happen on that first occasion is that your client will go to court and an interim order will be made, placing the child under the parental responsibility of the minister. This is a shock to a client because they haven't had the chance to be heard and they haven't had a chance to participate, and they're worried about what's going to happen. And they have no control over what is going to happen for their child, because parental responsibility for that child, which is decision-making responsibility, has been allocated to a government department. And those decisions are going to be about where the child lives and what sort of contact they're having. What's important, I think, as lawyers, but also most importantly as community workers supporting clients, is to say this is an interim order. That's a short-term order. The next stage in the proceedings, if you just go back the slide before, is the establishment stage. And the establishment stage is for the court to determine whether your child was a child who was in need of care and protection. It's called establishment because the court needs to determine whether your child was in need of care and protection for the court to be able to make long-term orders. If a child is not in need of care and protection, then the court has no power to make long-term orders. If the child is in need of care and protection, then the court has that power. So that finding establishes the jurisdiction of the court to make long-term orders. Clients don't get that. You can explain that to them a number of different ways, and it's a very difficult concept. It's a jurisdictional concept, and it's a jurisdictional fact that the court finds. It's important, however, to try and explain that to your client, mostly because establishment, making a finding that a child is in need of care and protection, is based on risk of harm and not necessarily actual harm. It's quite easy for the court to establish that a child was in need of care and protection because they were at risk of being harmed. And normally there will be a lot of evidence about what interventions have happened in the past and what the risks are. So often clients are invited to make to allow the court to move on to the real issue, which is what's going to happen for your child long term, by consenting to establishment or allowing the court to make that finding without conceding all the facts, and that's consenting on a without admissions basis. So you might hear your client talking about that. Next slide, please. Clients who are parents are a party to these proceedings, mostly. There's certain circumstances where they might not be, and they will be entitled to be represented. Clients who are parents for primary care and protection proceedings are entitled to be represented by legal aid, if they wish, by a legal aid funded solicitor, and there is no means or merit test for representation in primary care and protection proceedings until the matter goes to final hearing. And at the beginning of a process, it's not at final hearing. So any client that you have who's before the Children's Court and it's for a primary care and protection proceeding, which is their child has been removed, it's not final orders have been made and they're coming back, should be entitled to legal aid. And so one of the things that you can do as a community worker is to ensure that they know that and to work out how they can get legal representation for their participation in these proceedings, because they're complex, they're difficult, lots of mistakes can be made by a parent client, and those mistakes have significant impacts on a client. I'm just going to whip through this. Children are represented in care and protection proceedings. No, next, you can go to the next slide, please. Thank you. If they're under 12, they'll be represented unless they can demonstrate capacity to provide proper instructions. They'll be represented by an independent legal representative, and if they're over 12, they'll be represented by a direct legal representative. An independent legal representative acts consistent with what that lawyer determines is in the best interest of the child and has certain obligations to provide evidence to the court. A child over 12 is just represented by a lawyer who acts on their instructions. Okay, but they have to be informed instructions, and that lawyer needs to talk to them and give them advice about the options. Next slide, please. The placement stage is is where most proceedings are up to, and that is, can a child who's been removed, the placement stage is where most parents' issues are salient for the parent. So the issue is, can the child be restored to the care of the parent? And the law says that the department has to prepare a plan that sets out whether department thinks there is a realistic possibility of restoration of the child to the care of the parent. The presumption is that it's in the best interest of the child to be returned to the care of the parent so long as it is safe. And so what the parent has to do is demonstrate that they have addressed the issues that led to the removal of the child, and the court needs to consider whether if they haven't addressed those issues, great. If they haven't, will they do so within a reasonable time? And that's 2 years. And also the court needs to take into consideration the circumstances of the child. After a case has been established, it's probably a good time to consider what evidence the client needs to gather in relation to demonstrating that they've addressed the issues. And one of the ways to know that is to refer the client back to the summary of proposed plan, which is a plan provided to the parent by the department, which indicates what they think needs to happen for that child to be restored. It doesn't bind the department, but if the client can work through those issues, they often have a better chance of demonstrating that it is in the best interest of this child to be restored. Sometimes that evidence about their parenting capacity or their change can't be gathered from anyone else but by an expert, and you can make an application to the court for a children's court clinic assessment. A care plan is a long-term plan that sets out what the department thinks is in the best interest of the child, and the court has to decide whether to accept the care plan and whether the care plan adequately and appropriately addresses permanency planning for the child. The care plan will detail who has decision-making responsibility, whether the child will be restored or not, what sort of contact the child has with the parent, and what sort of services and supports that child may need if restored or if not restored. Next slide, please. What can you do? If a parent's seeking restoration, they'll have to show the court that they've addressed the issues that led to the removal of the child. And they'll have to show that they are able to work with services, because court's not over at child protection concerns don't end at final orders. So what does that mean for you? If you're providing a service to the parent and the matter's before the court, the fact that they're attending your service may be one of the issues in dispute. And so it can be really helpful if you can provide the client with evidence in support of whether they've attended, whether they've benefited, whether there's been change. If they've attended but they haven't benefited and there hasn't been change, it's really helpful for your client to know that early, rather than for you to report that to the department and our client to say, yes, but I went to this service and nobody told me. So I would encourage you to think about how you're going to be able to develop a therapeutic relationship with a client in the context of litigation, because one of the things you need your clients to do to trust you, but one of the things you have to do is to ensure the child's needs are the primary concern, and you might need to report what's going on back to the department. I believe that it's important to have those conversations before service is provided and to remind the client all the way through that these are going to be the challenges that we have. How are we going to work through this? The other issue for you to think about is the information that you're providing the department within your area of expertise. Are you saying that this client is suffering from a mental illness without being a psychologist, psychiatrist, or social worker who's qualified in mental health, or a psych nurse? Because that information may be relied on in good faith, but may be detrimental to the client if you don't have the expertise to know that. Are you saying the child had no bond or attachment to the parent because the child resisted an interaction? Is that within your scope of expertise? Are you seen by the client or the department as independent or aligned with the party? And if the client thinks you're aligned with the department, how does that impact on your interaction with them? Given there's a power imbalance and an evidential imbalance, are you able to provide the client with a letter of support or write a report? Often you can't. Let's talk about that up front, because it may be that rather than write a report, you'll have to have your records subpoenaed. Next bit of this slide. Clients' access to legal representation. Yep, so clients are able to access legal representation all throughout proceedings. They have access to a duty solicitor who will be assigned to them on the first day of proceedings. And I would encourage them to make or you as their support person to make contact with the legal aid office closest to the court to determine who that duty solicitor is and whether our client can have a discussion with that duty solicitor prior to the day of court. Often they can't, and often they only get to see their solicitor for 10 minutes before court. So imagine being someone who's had their child removed, the legal process has started, you've got a bundle of documents that can be up to 200 pages or more big, and you only get to talk to a solicitor for 10 minutes. It feels unsatisfactory, and it is unsatisfactory, and it means that it's difficult for a client to engage, but the resources that are available mean that that's the best that we can do for those clients. So if they can get early access to legal representation, early access to legal advice, that's really good. If it's a primary care and protection matter, they should be eligible for legal aid, and other people can join the proceedings. Now keep going, so I'll go as quickly. If final orders are made, often what happens is that clients need to know what their options are. It's important to acknowledge that if a client has had their child removed by a court order and not restored at the end of a litigation process, there's trauma in relation to the removal and there's trauma in relation to court. And if we're providing services to those clients, we need to be aware of that. Clients need a plan moving forward, but they may not be in a position to act right now. They don't need to feel accountable to their lawyers and to service providers. They don't need the burden of keeping us happy or managing our emotions because we were unable to get what they wanted. They need information, but they may not be in a position to hear it right now. And they need a connection to a service, but they may need distance and time to, just get wild. So we need to be aware of those client needs. Not every client will need this, and it's not up to us to determine what clients need, but that may be where they're coming from. Next slide, please. Final words. None of the options for a client at this stage are simple or easy because they've lost control of not only the legal dispute, but their child. Often the issues will relate to contact. So suddenly their contact's been decreased from every week to once a month. Their issues may relate to they don't have any information about their child or their well-being. They may have concerns about their child calling someone else mum and dad. And they may have concerns about continuing to have to do all this work for the department with no clear benefit to them in terms of it's not progressing their relationship with the children. So we need to understand that's where clients are coming from and try and work with them on each of those issues. Next slide, please. Mostly clients will want to know how they can get their children back into their care after final orders are made, and the provision in the law to do that is a Section 90 application. I don't have time to go into it in much detail, but it's important for community workers to understand that the law is really complex in relation to this. You cannot make an application to the court to seek to change a court order unless you get permission from the court. That permission is called leave. In order to get leave, you need to demonstrate there's been a significant change in a relevant circumstance and that it's in the best interest of the child. So to assess whether it's in the best interest of the child, the court will look at the child's view, the length of time the child has been with their current carer and whether it's stable. If it is stable, what is the least intrusive option for that child? And the court will then look at all these additional considerations, which is the age of the child, what the case is that the parent is asking for, what their plan is that case likely to be successful, and are there issues that the court needs to know about arising from that child's care? What's important in relation to Section 90 is that there is a window of time where parents need to be thinking about making that application. The longer a child is in a stable placement, the harder it is for them to persuade a court to change that placement, notwithstanding they've done everything that they need to do. So clients need time to cope with the negative outcome of losing their child and final orders being made, but they also need to be motivated to start working on addressing the issues and getting the matter back before the court. It's a very unenviable position for a client to be in, and it's a real challenge. And service providers really need to assist clients to understand those competing issues. Next slide, I think. There's also provision under the Care and Protection Act to ask for more contact than is provided for in the care plan. Most people think that contact for children who've been removed from their parents and placed in foster care is part of a court order. It's not. Mostly contact is contained in a care plan. If it's a court-ordered contact, Usually, unless there's a guardianship order, it can only be for a period of a year. So parents have issues in relation to contact. They might want more, they might want it unsupervised, and they might want it to be overnight time or extended time. The process available to a parent is to seek a contact mediation. And if that fails, you can ask the court. To get leave, to ask the court, of course, you need to get permission from the court, and the court needs to be satisfied that there's been a significant change in a relevant circumstance. Next slide, please. The other alternative before the department, after final orders have been made, is that you can ask permission from the department to approach the family court for some family court orders. The department will only generally grant permission when there's a contest between maybe a parent and a grandparent, where the child is with the grandparent and they want to talk about contact, or maybe restoration, but rarely. And normally the risk issues are clearly addressed, and the only issue in dispute is whether it's in the best interest of the child to have a relationship or a more significant relationship with the parent. The next slide, I think that is what you can do. You can be an advocate for your client. You can ensure your client has access to legal advice at all stages. You can assist your client to obtain legal representation when they're eligible for it. And you can ensure that the client has access to evidence within your scope, within your power. I think that's probably it. Conclusion, let me go. Community workers have a vital role to play in the process. The best outcome for a client is a trauma-informed collaboration between you and the client. It may not get the result that the client wants, but it may allow the client to understand the process so that they're in a position to start working towards getting restoration if that's a realistic possibility for them. I want you to think about what you really mean if you say a client's failed to engage, or what you really mean if a client is said to lack insight, and what the consequences of writing that might be. And also, clients need your help to access the services and get the evidence they need to work in this area to achieve the outcomes that they want. What we can do to help clients, what can we do to help clients focus on the system, what the system is trying to achieve, which is the care and protection of the children, is that we can help clients understand that system and understand how to work within that system. It's really hard, it's really unrewarding, but I think it's really important work that we can do. All right, I think that's the end, and I'm sorry I rushed it. Any questions?
Thanks so much, Daniel. You got through a lot of information. There is a question. If a client has ADHD and a history of trauma and performs really badly in family interviews, verbally oversharing past trauma, is there any way this can be recognised as inappropriate to family interviews? Children were removed due to messy house negligence when the client was experiencing past domestic violence.
Yeah, so I guess as a community worker for that client, that's where that advocacy role is really important. And what you can do is, if it's appropriate and your agency allows you to do it, is you can talk to the department caseworker about, look, these are the way this client communicates. What we need to do is focus on the actual risk issues, not in her capacity or his capacity to communicate with you. What way can we engage this client so that you can understand where they're at and what's important for them? And how can you work with that client? Oversharing is a real problem, and normally what you would do is refer them for some legal advice about the consequences of oversharing. But really, that evidence would probably be before the court anyway, so it may not be such a problem. And if they're the one thing that clients have in their arsenal in these litigation, particularly, is their capacity for their word to be relied on. So if a client is seen as someone, yes, they overshare, but they're reliable, they can be relied on to tell the truth, they can be relied on to do what they say they're going to do, then they can also be relied on such that the court can take some risks with them. So it may not be as detrimental as you think. I'm not sure if that's answered your question, but if you can work with the department to be more trauma-informed and client-focused, and it's not the client asking, but it's you as their service provider, you're much more likely to get a positive outcome for them.
Thank you, Daniel. And we've had another question. Samantha has said thank you for that answer. Anna's question is, what are a parent client's rights for contact with their child if they consent to adoption of their children?
Okay, so adoption's a whole nother area. No one has rights, they've got responsibilities, but an adoption plan in New South Wales you're saying consent to an adoption. It depends whether that's an adoption of a child who's been in the out-of-home care system, so that might be different. But the way I'm talking about is an adoption in the out-of-home care system. An adoption plan will cover what the court says is the minimum contact that should be occurring between the child and the biological parent. If that adoption plan is registered, then an application can be made to the Supreme Court to review that adoption plan in the event that it's not being complied with. I don't know if that really answers your question, but you can ask, I can take that on notice and we can talk about that further if you want.
That's all the questions that we have for now. So I think that we'll end the webinar. You did well, Daniel. We've only just gone 7 minutes over time. So I'd like to thank you very much for this presentation and to thank everybody for attending. And if there are any questions that occur to people after the webinar, please feel free to email them through and we can respond to them. So
thank you so much for having me.
We'll close off the webinar now.
Thanks.
Thanks,
Bye.
everybody.